Aha. All right, I'm ready whenever you are, Stacy.
Okay, great. All right, hi everyone. Welcome to this breakout session. Jessica and I are really glad that you're here. What we're going to do in this session is just kind of go through each of the pieces of the trial, the opening, the direct, the cross, kind of explain the purpose, what happens during each one of those. And then we'll go through kind of rules of evidence and objections, a lot of the things that people have been asking about. So we hope that this will give you like a good comprehensive overview of what mock trial is going to look like and how you can best prepare. So I think the best place to start is there's a plaintiff and a defendant. The plaintiff is the one that is bringing the claim, and they have to prove the elements of the claim. So you, I believe, got the practice case, and you may not have read it, and that's okay. We're not really going to go into detail about it. But what I wanted to show you is when you get the mock trial, like the actual case that you'll be presenting, the really, really important thing is that the plaintiff has to prove and the defendant wants to disprove the elements of the claim. So when I have my screen shared here, and it's the practice, the case packet. It's page 2, but it says here, Wild Blue is only liable to you, is liable only if you, the jury, find that plaintiff has proven by a preponderance of the evidence that, and it says 1, 2, 3. And those 3 things are the elements of the claim. And that's the backbone of the entire case. That's what you need to prove or disprove to win. So I think if I were preparing, that's the first thing, read the materials, but you're going to want to go back to this over and over as you're preparing. So I'm just going to read this. It's an example, but I'm just going to kind of go through it. So the plaintiff will have to prove the employment agreement between plaintiff and Wild Blue is valid, enforceable contract. Wild Blue breached the employment agreement when it did something, and then plaintiff suffered damages. So those are the things that the plaintiff is going to have to bring evidence through documents, witnesses, to prove those 3 things. Now, so the way that a trial goes is we start with the opening statements from both sides, and then we go into the direct and cross examinations. Jessica, do you want to go into the opening first, or should we just go right to direct and cross?
I think for opening, sometimes people tie their opening and closing together. For closing, your closing really needs to match what was actually presented in the trial. Sometimes what we see is that people have really, really scripted their closing, and it's like a beautiful little thematic thing, and it bears no resemblance to what was presented in the trial or was argued. And so while it might be beautifully presented, if it doesn't really match what was argued in the trial, that's where the flexibility part comes in. It's fine to mostly script it and have an idea of what arguments you want to make, but also being able to tailor it sort of on the fly or as you go along and thinking about different pieces of evidence that came in. So closing is a little bit harder to address just because it is really trial specific. And so I would just caution you not to be so attached to your script for your closing.
Yes, that is a great piece of advice.
Your opening can be scripted, beautifully scripted. We do encourage that you memorize it. Don't do it on your notes. Try to do it as naturally and freely as possible. The better you know it, the more natural it is. So if it's very stilted or uncertain, that usually tells us you haven't spent a lot of time practicing it. And so your opening, you can spend a lot of time. What Stacy just went through is what are the elements you have to prove? So you would say, first and foremost, we're going to tell you that this is a valid enforceable contract, and it's valid enforceable because both parties freely signed it. Nobody has revoked the contract. Nobody has changed their mind about, you would get into some of that kind of stuff.
Mhm.
Not getting really deep into evidence, but it can be scripted. And that's always fun for us to see how people have different approaches. There's no right or wrong way to do an opening or a close. Just with the close, just keep in mind, it needs to really match what actually happens in your trial. And then again, as I said on the rules, both sides have to give an opening. And if you don't, at least in the rounds that we run up here, you just get 0 points for that segment. And so you just have lost points. It's better to give one that you're not sure about than to not try at all, quite frankly.
Yeah, absolutely. So in the direct, the purpose for both parties is to tell your side of the story. And that's why being scripted is great. A lot of times coming up with your theme, in criminal trials, theme is justice or this or that, you come up with like your story. And you got a little flair for the dramatic. This is the time for it, is the opening statements. What you can't do is you're not giving evidence. What you're telling the jury is what they will see. So you can say things like, we're going to show you that this was a valid enforceable contract, and you're going to hear from this witness who will tell you that she voluntarily and freely signed the agreement with so-and-so. Something like that. So it's a good way to give the jury a preview of what they're going to see when you're presenting your case. That's something the plaintiff would say the plaintiff will go first, the defendant will go second. And so when defendant gives their opening statement, they can do, something similar. We're going to show you that this was not a valid and enforceable contract. You're going to hear from our witness that she only signed the contract because she felt like she had to, because her dad was putting pressure on her. I am making up these facts, but the point is you can say you will hear and we will show you. So it's a really good way to kind of connect these elements with the evidence that you're going to present through witnesses, through documents. Sticking probably to your witnesses is the safest course, but regardless, giving a preview of what they'll see so that they'll understand why these witnesses, why anyone's there, why are we here.
And it's also, you can sometimes do a little preview of what you think the other side is going to do in a way to like highlight, you're going to hear, as the plaintiff, you're going to hear from defense witness so-and-so. But what she may not tell you is that she was paid today. And we're going to demonstrate to you that she was paid for her testimony. And I want you to think about that while she's testifying and whether or not you believe that she's been bought off, or, however you want to spin that. I wouldn't spend a lot of time. I would say only if there's something particularly worthwhile in highlighting. It's better usually to focus your opening on your case and your witnesses and what you want to make sure the jury is listening for during your directs.
Yep, absolutely. And so, yes, this is definitely the time to give them a preview of your case. Go through each of the elements, what you have to prove, what you will show, or the plaintiff is not going to be able to give you, no one's going to come here and testify about this, or, there are documents that suggest the opposite. Actually, that's like, forget that. But my point is that it's your time to hook your witnesses and your evidence to the elements of the claim. That's the most important piece of it.
There's a question in the chat about whether or not you can have your notes during your opening and closing. The answer is yes, you can absolutely have notes while you're doing that. I'm not suggesting you can't. I would try not to be reading straight off of your notes, because that just sort of telegraphs that you don't really know what you're trying to present very well. So the more you can get off notes, the better, but you can absolutely have your notes, especially in close, if you've jotted down like things that you definitely want to highlight from the trial. Usually in opening, what we like to see though is people completely off notes. That gets the most points.
Yeah. And the opening is the easiest thing to memorize because you don't have to react, like we were talking about before. It's not like a closing where like maybe this document wasn't admitted to evidence, so talking about it's irrelevant. So you don't have to frame it as well with what happened during the trial. You can really tell your story. Okay, so let's move on to Okay, the direct examination. So direct is when first the plaintiff's case go, because they have to prove the elements of the claim. But each side has their section of the case. The plaintiff will have direct examination where it puts on its 3 witnesses. After each direct examination of a witness, the other side gets to get up and cross that witness. So we'll have direct examination 1, cross 1, direct examination 2, cross 2, direct examination 3, cross 3. Then the defendant puts on their case. They bring up their witnesses, direct 1, cross 1, direct 2. So that's the way that the trial is structured. And then closing. So it's really important to understand the purpose between direct and cross. They're very different. In direct examination, your witness is the star. You're telling your story by asking your witness questions. And who, what, where, when, why, how. Sorry, not why. Don't ask why unless depends. But what you're trying to do is elicit the testimony and look through the witness statement for the pieces that match with the elements of the claim. You ask the witness to introduce themselves, and then you know, why are you here? I'm here to testify about a contract. And this is something where you can practice a lot with your witnesses. And this is the time really for your witnesses to shine. This is where a lot of teams will, it's easy to get points because the witness can, know your fact pattern cold, get into character, and the witnesses can really steal the show. It's actually really, really fun. And the witnesses, like I said, you can practice. They should already know, you should know what they're going to say, and they should know their story, where they're going with it. Let's see. During direct, sorry, hold on a second. There we go. Okay, and then you also introduce exhibits. So in your case packet, you'll have all these pre-marked exhibits. Some of them are documents, some might be a picture, different things. And so you do that through your witnesses. But it's got to follow the story. So, you ask your witness why they're there, what's the point of their testimony? And then if there's a helpful document or something like that, that's where you introduce the exhibit. And like Jessica mentioned earlier, what's the rule number that is the introduction of evidence?
I believe it's 4.20 and 0.1 and 0.2.
Yes. So if you need to do one thing, go memorize that. It tells you exactly what to do to introduce evidence. Do you want to go through it, or I guess?
Yeah, I can pull it up and just go through it very quickly if y'all think that would be helpful. I think the main thing is you don't have to say it necessarily word for word, but like it has the actual like questions you can ask. So I think that's really helpful.
So let's do like an example. So an example is, this, we're not really going into this fake case, but it's a contract claim, right? So probably one of the first pieces of evidence you want to introduce is the contract itself, the document. So you're talking with your witness, and we'll just do it. They're all pre-marked, and they will have a P1 or D1 or Exhibit A. I think they're usually numbers. But you mark the exhibit, you ask the judge if you may approach the witness, you give a copy to opposing counsel, let them look at it to make sure it's the correct document. So if you're trying to introduce the contract and it ends up, it's a contract that's all marked up or something that's not actually the exact piece of evidence that
the main thing, the main
thing
thing is that you're not supposed to annotate or mark up your exhibits in any way. So you're just showing, I would just show them the actual thing you're about to present. So the other side can just make sure that it's the exact exhibit that was in the case packet.
Yeah. And this is not like a big deal, but it is an important formality. So you're not going to get objections unless the exhibit doesn't match what we have in our packet. Okay, and then the whole point of this is to establish foundation. So you go and say, hand it to the witness. Do you know what this is? Yes, it's a contract. Do you have personal knowledge of this contract? Yes, it's the contract I signed on this date. Is it in the same or substantially same, is it in the same position? Geez, is it in the same condition as it was when you signed it?
For the contract, is this a true and correct copy of your the contract that you signed, or like some way to identify? Like, it doesn't have to be perfect, precise language every time, but you want the witness to say, this is the thing, this is how I know it's the thing, this is what proves that it's the thing that it is.
Right. And so the witness says, yep, this, take a look. The witness goes, yep, this is the 5 pages of the contract. Is that your signature? Yes. Okay, great. Then you can ask questions about the contract, what the witness, what certain of the paragraphs relate to, why did you sign it? Well, what the contract was is I give this much money and they give me their dog, something like that. So, but then what happens after, then you ask to enter it into evidence. And when that happens, what actually in practice happens is that means that when the jury goes to deliberate, they get to take all the exhibits with them and look at them later. And so that's why it is really important in mock trial too, to actually try and get the exhibits into evidence in addition to the testimony that you have, because you want the jury to have, the contract to look at when they kind of forget or want to refer to something when they're trying to make their decision.
And I have seen that as a practicing attorney, that the other side kept forgetting to offer their exhibits into evidence. And so when they got to the end, it's like, well, that evidence was actually not admitted and they weren't allowed to talk about it in closing. So
and that is something that is very bad if you do that as a trial.
Yes. But even in mock trial too, like you might lose a point or two if you're not actually offering your exhibits into evidence. So that's a really important part of it is, again, the other stuff doesn't really have to be precisely perfect, but if you're not saying we offer exhibit number 1 into evidence, you're probably gonna lose a point or two there because you didn't actually get it into evidence, so it's no longer relevant.
And what happens a lot in mock trials then after, the judge, if there's objections, you hear them at that point. So the other side would then, when you're asking to offer it into evidence, that is the time for the other side to object. You do not have to wait for them to object. They don't have to object. But if it's going to happen, that's when it happens and when they want to object to that particular piece of evidence. They can also object to questions that you ask, but just to make clear, like that's when the objection to like the document would happen. Whenever any objections, if there are any, are resolved and the judge, for example, says, yep, exhibit A is admitted into evidence, oftentimes you'd say, may I publish it to the jury? The judge will give you permission and then you go hand the document over to the jurors and they can look at it or not look at it. So aside from the documents, I like this last point here, that make the jury like your witness. You're telling your story through these people. And, like some of the more advanced intermediate kids said, that this is actually, the witnesses are so fun. And it's a really great, way to be kooky or charming or tell your story. It's really great to see people really get into the role of a witness. Pull at the heartstrings of the jury, things like that. So just the key here again to remember is that the witness is the star. As the attorney who's giving a direct examination, this is not, and did this happen? This is not the time for pediatrics where the lawyer is the one who steals the show. This is the time for the witnesses really to shine.
There's a question in chat from Taylor. Are witnesses allowed to talk about things from the case materials or just their statement? Witnesses are bound to their witness statement. That is a rule. So if the witness can't, witness A can't testify to something that's on witness D's fact statement, for instance, unless something about witness A's statement indicates that they have personal knowledge of it, right? Now, as far as exhibits go, in theory, any exhibit, you could try to enter an exhibit through any witness, but you're going to always have that personal knowledge issue. If a witness doesn't have personal knowledge of an exhibit, it's not generally going to be able to come in through that witness. So I would just go back and remember that witnesses are bound by their statements. If it's not in the 4 corners of their statement, think very, very carefully about whether or not they would know something outside of that.
That is a great point. Okay, so let's go on to cross. Okay. Did I just skip a slide?
I think it's, yes, I think it skipped one. Maybe? No, I think that's the right slide. I don't have it open. Let me see if I have it open.
Okay, yes, there we are. Okay.
You're on the right slide.
So cross-examination, we're doing kind of the mock, right? So the plaintiff just put on their witness. Now the defendant, one attorney, is going to cross this witness. So only one attorney gets to do cross. And this is where you poke holes in their story. You should ask closed or leading questions. And you've probably heard people say, control your witness. You do that by asking these leading questions. Yes or no? Did you know this? You didn't sign the document, did you? At the time, you didn't know that this was going to happen, did you? Stuff like that. So you really want to limit them to yes and no questions. You should also, and this is a great point, you should also know the answers because you've studied their witness statement. So you should know exactly what they're going to say. The cross-examination questions are meant to poke holes in the side of the case. So I would say, like, strategically think about whether, we can all be argumentative and poke holes in every single thing a witness says, but if it's not going to help your case, think about whether or not it's important to do. I think actually, as a practicing trial attorney, one of the things for cross-examination is to know when to sit down. If you've made your point, you can be done. Okay.
I think, Olivia, is this a witness question that you're asking? Can you say yes or no? Yes. Okay, Olivia asked, what if we don't know the answer because you forgot, or they're just a really obscure question? First of all, it says if you forgot, it's fine to say, I don't remember. Don't be surprised on cross if the other side hands you your witness statement and impeaches you if you're saying that too much. If you say it's an obscure question or you don't understand it, it's also okay to say, I'm sorry, I don't understand your question. Can you rephrase it?
Absolutely.
Now, if you do that for every single question, I'm going to be suspicious as to whether or not you really don't understand the question. But if you have to say that once or twice, that's totally fine and acceptable. That's being a good witness, is making sure you understand the question that you're being asked. Can we use witness addendum to ask questions in direct? Absolutely. The addendums to the witness statements are considered part of the statement. Okay. Yeah. So when I say you're bound by your witness statement, I mean the initial statement and the addendum. That gets a little case specific, but
that's a good point. We usually see those where at least one witness in the case will have their statement, and then they'll make an addendum that either adds some additional information, but sometimes they will say, in my prior statement, I said this, but now I'm saying Z. So, it's a good idea in direct to address those inconsistencies, because you can imagine on cross-examination, you're going to hammer the witness on that point. But before you said, you said that you signed the contract willingly, and you signed that document, didn't you? So at the time you said truthfully that you signed the contract, something like that. And so that's a good, that was a great question about the addendums, because those can be important. And that's a good question also, because if you're really honing in on the fact statements, which you should be doing, there will be some little inconsistencies here or there.
I'm forgetting what the term we use as lawyers is, Stacy, but also make sure, like, if there is sort of a bad fact in your addendum, it's very helpful to try to address it in the direct in a way that sort of minimizes it or makes it not a big deal, to sort of undercut the cross-examination. So if you
take the sting out is what we
let's just all be on the same page. You did issue an addendum and you did have to correct some things, and as a way to sort of take the sting out of it. there's a question, Stacy, what do you do as an attorney during cross if the witness refuses to respond only with yes and no responses?
So that's a great question. And I will say this happens and it can be very frustrating. It also happens at trial for practicing attorneys. And, you know, you can take a breath, because it can be, as the attorney during cross, take a breath. Don't get flustered. Think about rephrasing your question to make sure it is a clear yes or no question. If you need to rephrase or ask it a few different times to get that phrasing right, to make sure it's very clear yes or no, that's fine, do that. But eventually, if they're not answering the statement, you can actually ask the judge. Jessica, would that be in the rules?
So yeah, you can absolutely object as non-responsive. What I do as a practicing attorney, and what I like to see also, is sometimes just as the attorney and controlling the witness, Stacy, I'm asking you a yes or no question. Is the sky blue today? And if she still will not answer yes or no, then I immediately object non-responsive.
Yep. And that's a great point, because highlighting for the jury that the witness is being difficult, that makes the witness look bad.
Yes.
I asked you a yes or no question. I'm going to ask it again. And then that is the only time where you object. Well, it's not the only time, but you'd say objection non-responsive. And then hopefully you've been asking the question clearly. And if it is non-responsive, they're just not saying yes or no, the judge is going to order them to answer the question yes or no.
Yeah. And a lot of times in mock trial, the presiding judges like to ask you, well, why are you objecting non-responsive? You just say, I asked a yes or no question and she didn't give a yes or no answer. Yeah. That's all you have to say. And you just clearly put on sort of the record why you're objecting. Is asked and answered an allowed objection during cross?
So that is an objection that, yes is the answer. The context is a little different. So if I am doing cross-examination of Jessica's witness, okay, she's the plaintiff, I'm the defendant, and I am doing cross-examination, and I am just keep asking a question over and over again, Jessica will object to my questions as asked and answered. If the witness already gave me the yes or no, and I keep asking it to hammer the point, at some point, Jessica can object and say asked and answered. And
yeah, I think in the rules,
but that's what happens.
Yeah, I think in the rules, we also call it repetitive. Like we're just asking the same thing over and over. Now, what sometimes I see that objection for is like, maybe I asked it on direct and Stacy's asking it again on cross. And then if I try to object to repetitive, it's probably going to be overruled, because a lot of times on cross, you might re-ask a question just so that your immediate follow-up question now has clear context, right? I may re-ask her, in your direct, you testified XYZ. Is that correct? Yes. Okay. And then I'm going to hammer why I think maybe she lied, or maybe it was inconsistent with some other part of her statement or whatever. It would be weird for the other side to then object to repetitive just because I'm sort of reiterating it. Now, if I asked her, maybe not the second time, but definitely the third time I'm asking the same question, that's when we're going to get into asked and answered and repetitive type objections.
So it's an objection that's it's not always helpful, I guess.
But it can be, because
it can be very helpful.
Because sometimes you as the attorney think, well, they're not answering my question, so I'm going to keep asking the question over and over. But the reality is that they did answer the question that you actually asked. So that's why, like Stacy said, the advice is good to just like take a breath, think about your question. Did I ask it in the way I meant to ask it before you just say it again?
Great.
Those are great questions, though.
Yeah, very good. And so the other, so we talked about how in direct, the witness is a star of the show. In cross-examination, the attorney doing the cross-examination is the star of the show. This is the theatrics. This is, you see the movies, and this is the fun part. It is fun. And this is where you can also introduce exhibits indirect You might think about entering an exhibit that refutes the witness's point, or that, yeah, entering exhibits that would be helpful to your side. And you would do that same dance that we walked through. There's no, as long as it's an appropriate piece of evidence to ask that witness about, it doesn't matter whether you enter it on direct or cross, but you do want to get those pieces of evidence in.
And I guess it's just an extra point. Once it has been admitted to evidence, you can present it to any witness and have them look at it and comment on it, whether they have personal knowledge or not. Like, have you ever seen this? Nope. Okay, great. Just putting on, that's a way to refute. Like if someone said, for example, we signed a valid contract, and Stacey's like, no, we didn't. I don't have that contract. Like, me as her attorney could say, did you actually sign this? Nope, that's not my signature. So once it's been admitted, you can represent it. You don't have to readmit it. You don't have to go through the whole song and dance again. You can just say, I'm showing the witness what's been previously admitted as Exhibit 3.
And so, like a good opening and good direct, you're going to really study if you are cross-examining a witness, you're going to really study that witness's statements and, plot out the points that you want to make. Like one point I would want to make is that, she did not voluntarily sign the contract. And so if you're going to, ask questions that are going to get you to prove those points, and then, if there's other questions you want to ask, sure, but, end on a high note, end with a good solid question that helps refute their case, and then sit down. One of the things I don't know if we said, but you don't have to take the full time. Obviously you should, there's lots of facts in these cases. And so there's enough material that you probably should use a lot of the time, and often teams do. But if you got all your points and you made all your points and it was clear, you don't have to keep going.
Yeah, and remember that you have a chunk of time for your directs and redirects. It's not per witness. It's for all 3 of your witnesses, and the same for your crosses. So sometimes, a couple years ago, we had a comedy festival case pattern, and one of the plaintiff witnesses was the organizer of the festival. Like most of the really key facts of the case were in that witness's statement. So it made sense that they were like 15 to 20 minutes of that 25, because almost all the key facts were coming into that witness. It doesn't make the other witnesses less important necessarily. Every witness statement has something that is important about their statement, or we hope should be there, that's important. But it does mean that sometimes you want to make sure that you're spending enough time on the right witness, but also making sure you're not spending all of your time on one witness, because that would suck, because then you can't present your other witnesses at all. So you have to be really careful of your time. That time is for all of your witnesses, not just for one of them.
Okay, redirect and recross. Now, these definitely happen, but we just want to emphasize that this is not something that just keeps going on forever. So you have one redirect, one recross, and it's always limited to the scope of the prior. So for example, Jessica put on the first witness as the plaintiff, and she asked all about the contract, and when they signed the contract, blah, blah, blah. She can't then in redirect get up and ask about something that has nothing to do with any of that. Or if she forgot to ask a question during direct, but it never came up, you don't get to introduce new evidence during redirect or recross. A good thing to think about when you're doing a redirect specifically, on cross, your witness, there's always some bad facts or some things that don't sound great during cross-examination. So during redirect is a great time to say, on cross-examination, they ask you a lot of questions about this. Can you tell me why? That's a good time to give your witness the opportunity to explain facts that sound bad, or explain the circumstances that came out that didn't sound so good.
Yeah, what I have as a practicing attorney have sometimes told my witnesses to do is if you're asked a yes or no question and your answer is yes, but say yes, but you may not get to finish that sentence, but that clues me in to ask you that clarification. Let me ask the question so you can tell me everything after the but that you think was important. Because that's a really good signal, but also think to yourself, even if your witness doesn't say the but you hear them like, I asked Stacy a question and she says yes, and in my head I go, but so and so, like, let me write that down so I can ask her as soon as I get her back as a witness, so that I can sort of clean that up and give that further context. Because sometimes yes or no questions don't make you look good.
Yeah.
As the witness.
Yeah. So, and when you're prepping your witnesses, when you're working with your witnesses about what the case is going to look like, you should know what question, what are their weak points so that you can be sure to be prepared to explain them on redirect. It is a chance to get the last word, especially for the other side if they're doing recross. Again, it's limited to the scope of the subject matter that was in the prior examination, but oftentimes, like on recross, it's going to be 1 or 2 questions to just elicit those bad sounding yes or no answers. But I think when you're preparing, you're not going to prepare a lot of redirect and recross. You want to make sure to get your evidence in direct and to make your points in cross. Redirect and recross is a lot of clarifying and emphasizing, I guess I would say.
Yeah, redirect and recross is hard to plan in advance because you don't actually know what's going to be elicited in the. I mean, you should. I mean, actually, you guys should know what's coming out in cross because you have access to both. You have access to the whole problem. So you should think through, what do I think they're going to ask on cross? And so, to some extent, you can sort of plan a little bit on redirect. But like Stacy said, you should be doing that in your direct to begin with. I would not wait and hope for the redirect portion to clarify properly. I would try to get it all out on direct if possible. Does anybody have any questions about that part before we move on? No.
And one thing, this is kind of silly, but when you're introducing yourself at the very beginning, opening, when you're introducing yourself to the jurors and judge, typically you're going to say, my name's Stacy McNulty, for the defendant. I will be doing opening statement and cross-examination of Jessica's first witness. So, you are always going to be doing these specific roles or tasks. So you're going to introduce that initially. So you should always make sure those are assigned very clearly within your team.
And how you decide to do that is totally up to you. I know y'all are a lot of beginners, so so we sometimes get that question is, how do you assign it? Stacy doesn't have to, in her first trial, when she's the plaintiff side, she doesn't have to direct the same witness that she's going to cross when she's on the defense side. You can, sometimes it actually maybe strategically is better to have a different witness do the cross because it helps you be just a little bit more hostile, not hostile in like a mean way, but it helps you be just a little bit more negative, where sometimes when you're just like really focusing on like your direct, you want to make sure you're staying really positive towards your witness. And so sometimes it can help, but however you decide to set up your team is usually like, it's up to you guys. Is time stopped after every witness, and or what is the format? Timekeeping has really specific rules, but usually it'd be a very brief pause, like while the witnesses change. But then as soon as the witness is seated and the judge says you may begin, the time unpauses.
So when each party, so the plaintiff, if we're going with our example, when they call their first witness, the witness just to be very clear, the witness comes up to the stand. You do direct, you do cross. I don't know if we clarified, but redirect and recross need to be the same people. So if you did direct, you have to do redirect. Another person from your team cannot do redirect. Same with cross and recross.
Yes, that's a good clarification. One attorney per witness, period.
Yep.
And whoever's assigned to that witness is the only person who can make objections.
Mm-hmm.
Now your teammates can like pass you objections or tell,
Yeah.
I've seen where they have like the major objections like on a sheet of paper and they just sort of point, like I think like I heard hearsay, but if you say objection hearsay and the judge asks you to explain it, you're the person who has to explain it. So sometimes that's not super helpful to have your teammates telling you objections necessarily.
Mm-hmm. Okay. So we thought it might be useful then to kind of go through an example. Do you want to do this or do you want to go into evidence? Do you think, Jessica?
It's already 11. Okay. So it might be helpful to hit the evidence stuff first, and then come back to like some examples. Do we have to explain objections? Only if the judge asks you to. And sometimes in mock trial, we do a lot of times ask because it's not enough for you just to stand up and say objection hearsay. I want to know that you understand why it was hearsay to begin with. And we'll ask for a response from the other side because maybe there's an exception to hearsay, right? And so we're gonna, a lot of times give at least the first couple of times an attorney makes a certain objection, we might ask for an argument. Now, obviously, if you're on direct and like if I'm asking questions on direct and Stacy is objecting to leading, the presiding judge probably is not going to make her explain why she's objecting to a leading question if it's obviously leading. Maybe the very first time, she'll be like, she's on direct. She asked yes or no question. That's not permitted. Okay, sustained. And then if I keep doing it, she keeps objecting it. The judges will just be like, sustained, overruled, like whatever. And some of our presiding judges like to rule incorrectly just for the fun of it. I'm just gonna caution you on that one. And when I say for the fun of it, they want to see how you respond.
Mm-hmm. So one thing as both an attorney and a witness that judges look for, and this is very true in practice as well, is sometimes how you react is more important than what you say. So maybe you lose, you say objection and the other side and the judge overrules you and you feel so stupid, but don't look like the whole case is thrown. Oh no, you just, okay, fine, not a big deal, sit down. Yeah. I think that's an important thing to remember. And also because like we all get nervous and you feel like, oh no, I didn't ask that question right, or I'm the witness and I feel like I answered this, on cross, you're feeling like you're giving up the case, but just remember that keeping your cool can be much more important than what you
yeah. I think I had an example a couple years ago on a case. I was not the presiding judge. And this was one where the presiding judge liked to just rule incorrectly just to see how people would respond. And the attorney was like, the other side kept objecting to the form of her questions and she was doing really well until like 3 in a row got sustained and they actually were proper sustained. And she just stopped asking questions on direct.
Yeah.
She just stopped. So part of her direct never even came in. Like some of the key facts never came in because she just gave up, because you could see it that she's just like, oh, all my questions are being objected to and sustained, so I can't ask any questions. And so like Stacey said, take a breath, keep your cool, think about how you ask the question, and keep going, making sure that you are getting your key facts in.
Right. Yeah. So like, for example, the plaintiff in a contract case, it is critical to talk about the contract. So you need to make sure you've established, it was signed, the terms with your witness. So even though there might be some objections and you're getting frustrated, take a breath and continue to make the points that you need to make. That goes a long way. Okay, so we're going to talk about evidence and objections. So evidence is anything that supports the elements of the case. It's what you use to prove that the elements of the case have been met. There's different kinds. So here's an example. Defendant says he did not murder his roommate. Can you guys think of like what type of evidence? We've got eyewitness testimony. So we call a witness. That is a type of evidence. It's testimonial evidence. There's documentary evidence. So a document. There's a knife, you know, the murder weapon. That's a piece of evidence. There's also demonstrative evidence, which we'll talk about a little bit later, but there's all different kinds of evidence, and you're going to have all of these kinds in your case. Obviously, you have witnesses, and then you're going to have your packet that has pictures and documents and things like that.
Yeah, testimony is evidence, and it is important evidence. As an attorney, I oftentimes have clients like, well, I just don't have any evidence of what, and I'm like, you have your story about what happened, and that is just as important. While we love to have pictures and documents, all these other things, your story is also just as important.
Right.
And so think about the rules of evidence as they apply to the questions and the testimony itself, not just to exhibits.
Yes, absolutely. So they're important to make sure that the jury is actually looking at the true facts of the case. That the jury is hearing from people that actually have knowledge about something. So if I have no part, I didn't sign the contract, I didn't write it, I didn't negotiate it, I shouldn't be testifying about it. And it, for example, so that was about testimony. A document that looks like the contract but has different words and wasn't signed and is actually not the contract should not be admitted into evidence because it has nothing to do with the actual contract that we're talking about. Judicial notice is basically means like things that are very obvious. You can ask the judge to take judicial notice. This only comes up a little bit, but it's something that's, what goes up must come down. Those are kind of things that are judicial notice. I have no idea if the Cubs won the World Series. I don't know that that's a real one.
I think they did. I think that one is correct, actually. Sometimes for the judicial notice for you guys, it's like taking judicial notice of the stipulations of the case.
Yes.
Because the stipulations we were asked about stipulations earlier, and I think we totally forgot to come back to
great.
it. The stipulations, if you look at like our practice case for today, for example, it starts off, these are the stipulations. The parties agree and stipulate as the following. It's a civil trial that will be tried before a jury, and the parties will only try the issue of liability at this trial. So we say that's a stipulation because that means we're only talking about liability and those elements that are specifically listed there. We're not talking about whether or not the recording company is a bad company, whether or not they committed other crimes, things like that. We're stipulating to these very narrow issues that are being heard today, okay? And it also is stipulations as to jurisdiction and some other boring lawyery stuff that if we didn't put those in the stipulations, we would have very advanced students trying to make those objections at trial. So you as beginners don't need to worry about some of that. Those are really just to keep some of our advanced students from being a little bit too advanced. And then some of it just,
sorry, go ahead.
Yeah, no, some of the stipulations are just naming the parties, naming the cause of action, naming certain pieces that they agree to, because what those stipulations mean, for example, in our practice case, it is a stipulation that the parties agreed that the employment contract would last for 1 year. So no witness may testify that there was an agreement it was intended to last 2 years or 6 years or anything else, because they are stipulating that they agreed it would last 1 year. That is where some of the important fact stipulations come in, right? So if, for example, the plaintiff in the case said, well, I signed the contract and I believed our agreement was that it would last 2 years. Objection, Your Honor. The parties stipulated that it was an agreement to last for 1 year. Okay, so some of them are really important key facts of the case. And again, we put those stipulations in just so we can narrow the issue and make sure the trial can last 2.5 hours instead of 4 days. Because that would not be a lot of fun for anybody if we had to keep going back on a mock trial case. Will the slideshow be available? I think we are going to send the slideshows out. And also we are recording, and so I think the recordings will be made available as well, so you can go back and watch us talk all over again if you didn't get it.
You can watch me just butcher admitting evidence. Okay, so these slides that we're going to go through next are they're the rules of evidence, but they're also going to be like the objections that may be raised. So relevance. Evidence has to be relevant to be admitted to the case. How do we know if it's relevant? Well, if it makes a fact that you're going to use to prove the elements more or less likely. So evidence about a dog or evidence about someone flying a plane has nothing to do with the contract. So even if it makes him look bad and you want to ask about it, you'd object and say, that's not relevant. We're talking about a contract case. Whether or not he had a dog has nothing to do with this contract. That is a bad example, but it's when logically they're completely different.
Yeah, and as a case writer, we love to put things in that are not relevant, to the particular cause of action. So just because it's in the statement doesn't mean it needs to be testified to.
Yes.
We don't do it a lot of the times, but it is fun to just throw something in that really has absolutely nothing to do with the case at all. And that's when you can bring up like a relevance objection.
So one of the important things, a relevance objection, an important time when you would want to object is when the evidence is inflammatory. So it sounds bad, it looks bad. The jury could just get really mad at the person and think he's a bad guy, but it has nothing to do with the actual facts or the elements of the claim. So you'd say, objection, this is irrelevant and it's more prejudicial than probative. So it's going to mislead the jury, something like that. So in these slides, when you're preparing, look at, the language. If it's important is outweighed by prejudice, confusion. Those are the words that you're going to need to say to explain your objection or to respond to an objection. Okay, back to the murder case. So relevant evidence of whether or not he committed murder, video footage, the autopsy report. Let's see, text messages showing they'd been fighting. Testimony from the defendant's mother that he hated to do dishes more than anything. Sure. Can you guys think of like other types? What would be relevant to whether or not someone killed their roommate?
I think you have to read the point above that, which has to do with they were arguing about whose turn it was to do the dishes.
Oh, there we go. Yeah. Okay. I was like, I don't know. I was like, I would definitely. It would be relevant to know whether or not he was living there at the time, or, it'd be relevant for him to say, I'd been staying with my, this person for the last week because, the decedent was playing loud music all the time. So that would be relevant to where he was at the time of the murder. Irrelevant. Eye color, zoo animals, the dog example I said earlier. Elementary school, football teams, ticket stubs. Anything that doesn't have to do with murder, when it occurred, why it occurred, how it occurred.
Yeah, we don't have a criminal case this year, but sometimes in our criminal cases, our witnesses will have all facts about where they were at every single time except for when the person was murdered. And those things are not relevant. We don't care about where you were 3 days before or 7 days after. We care about where were you at the time of this thing. And so that can help you understand relevancy a little bit more.
So an example is like, if, let's say on direct, I'm saying, okay, well, 3 days before the murder, weren't you volunteering and at a shelter for kittens, and weren't you donating all this money? And, you know, maybe the other side would object and say that that's totally irrelevant to the murder, whether it happened, that's irrelevant to what we need to decide today. Character evidence. This is kind of like what I was just talking about, is a person's character can't be used to prove whether or not they did something on a specific day. So like I just said, like the fact that he volunteers with puppies and donates to charity is improper character evidence, because it doesn't tell us, it cannot tell us whether or not he was there and committed the murder on that day. Well, let's see, we're not in a criminal case, but an example of this is you can't use evidence of a prior bad act to show that they did a bad act on this occasion.
And sometimes the objection, you actually have two objections there. It's not only is it improper character evidence, but it's more prejudicial than probative also. Because the reason we keep that out is because sometimes, you know, a jury could just latch on to this one bad act they did, completely, you know, irrelevant and unattached to the actual case that is in front of the jury that day.
So we talked about, when we were going through kind of putting a witness on for direct, or, you know, questions that you'd want to ask, a very important piece of the foundation for this evidence is that they have to have personal knowledge. So they need to have seen or observed or heard something or done something. This doesn't apply to your experts, and you'll probably have an expert in the case. But a witness has to have personal knowledge. Did you see this? Did you talk to this person? Did you sign the contract? Did you talk about this at all when you were negotiating the agreement?
You probably can't ask, like in this case, the plaintiff, you can't say, do you believe this is an enforceable contract? Is there not necessarily an expert on contracts, but they can testify. I mean, I signed it. I thought it was valid.
Yeah,
I wouldn't have signed it. I wouldn't have signed it if I thought it was going to be an invalid piece of paper. But they can't necessarily testify to like the final, you know, piece of whether or not it actually is. I mean, all they can do is say their opinion, but that would be examples like a lay witness. They're not an expert, but like I wouldn't have signed that piece of paper if I didn't think that, you know, it was going to be enforceable. But maybe the other plaintiff's witness can't offer an opinion at all because they didn't sign it. They weren't part of the conversation and they're not an expert. Whereas if they were maybe an expert in contract law, they could say it meets all the conditions of a contract, blah, 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 blah. Like I wasn't party to it. I didn't sign it, I didn't draft it, but I'm an expert on contracts and this is what it says.
Yeah.
So that would be sort of the distinction.
Yes. So there's the lay regular witnesses, and then there's the expert witnesses. And if you're putting on an expert witness, you want to go through like their qualifications. Okay, you're a contract expert. How many contracts would you say you've negotiated over the last 10 years? 1 million. You know, have you worked for big companies? Yes, I work for huge companies. I do all their contracts. You know, stuff like that to establish that they have this specific knowledge that they can give an opinion on. Oops. Okay, I guess we should get into hearsay now. Hearsay is the toughest concept. Hearsay means that you are offering an out-of-court statement for the truth of the matter that is asserted. So let's see. Here we go. Joe says, Anne told me she saw the defendant kill his roommate. Joe, so here, Joe did not see. Joe has no personal knowledge. So the whole point of offering this statement, Anne told me she saw, is to prove that it's true. But Anne is not there testifying, so that is hearsay. That is an out-of-court statement, which is Anne's being offered for the truth of the matter asserted. Okay. The lab report that says the blood on the lamp matches the roommate's blood. If you can bring in like a representative of the lab, then you could enter it, but otherwise it's just a report and it was made out of court. Okay. Okay, maybe we should give some more examples of hearsay, I think. One that my evidence teacher used to love, and I thought it was a good example, is a piece of mail. Here we go. It says, Stacy McNulty, blah, 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 here's your account. It says information on it. It says my address. If we're trying to put this piece of paper into evidence without me to show my address, that would be an out-of-court statement being offered to show my address. Instead, we would need to bring Stacy to court to testify and talk about her address. Okay. I don't know if we want to get into the
I think generally in response to Rahul, I'm not sure how you pronounce it, I apologize. Question, if an article published about a character, they have admitted it pre-trial, we do sometimes have in our stipulations, we will stipulate that an exhibit is admissible. And what that means is that there is not an objection that can be raised to hearsay, relevance, authenticity, any of those things. Now, it still has to be actually put into evidence, and you generally want to put it in through someone with some amount of personal knowledge, but you're not going to be able to raise those like hearsay objections if the stipulation says that it's admissible. But and that sometimes applies to one or two exhibits, but not usually to.
So just know what they are, because that would be you'd respond, and if they said objection, hearsay, if that's in the stipulation, know that so that you can respond and say the parties have already stipulated.
Yeah, and I think an example is last year. I'm looking at last year's case because we can't talk about this year's. I couldn't talk about it anyway. I don't know most of the facts. Despite helping write it, I don't know anything about it, to be very honest, you guys. Last year we had a newspaper article, and one of the stipulations was that the newspaper article, which is a public it is a public record and it is admissible in evidence at trial, even though technically it's hearsay, right? Because it contains a whole bunch of stuff that was out of court statements. It was stipulated to, and public records are actually exceptions to hearsay, usually anyway. But sometimes we just don't want to have people spend time having to argue about those objections. So we'll just, that's a stipulation, it was admissible at trial. And for those pieces of evidence that are stipulated as admissible, you can present them at really any time. It's really helpful to do it with somebody who has knowledge of it because it helps to tell your story. So it's sort of like you could at the opening of your case say, at this time we offer exhibits 1, 7, and 8, which are admissible per the stipulations, and you could get them in that way. It doesn't help the jury understand why they're important if you do it that way.
So I think this other bullet point here, talking about the statements offered against, so it's called the prior inconsistent statement. It's if you're offering it not for truth, but offering it to show that the witness might not be credible, then it's not hearsay, because you're like, I don't really care whether it's A or B. I'm just trying to show that the witness doesn't know what they're talking about. They changed their story. So that's what this second bullet point is talking about. Okay. So these, this list here are hearsay, exceptions to hearsay. So when someone says objection, hearsay, this is an out of court statement being offered for the truth of the matter the matter asserted, these are some exceptions. And so this would be then the response to the objection that would help you overcome the objection and get this into evidence. So present sense impression. So I heard the roommate say that's such an ugly lamp right before he died. Excited utterance. This is one that actually I feel like I've seen a lot of times. It has to be, they have to be an excited utterance, where typically, you know, if someone is so taken.
Let me read the rule, because an excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. And so this would be, for example, if, you know, someone was, you know, assaulted in some way and that person is crying and blah, 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 and Stacy's the witness, Stacy can say, well, I heard her say X, Y, Z. And so it's really helpful to, in that case, if you think it is an excited utterance and should be admissible, it's helpful to put on first why you think they were under the effects of that event or condition, right? So maybe elicit, well, the victim was crying, she was having trouble like controlling herself, she was just talking and rambling. It wasn't really, she wasn't clearly thinking through what she was saying. Because that's why sometimes we let excited utterances in, because it's indication that the person, like if I'm testifying to what that person said, they weren't really lying, like they weren't spending a lot of time thinking about what they were saying necessarily.
They didn't have the opportunity to think of a lie.
Right.
Basically.
So it's helpful just to be like, well, this is why I think it, you know, helpful to lay that foundation first of like why they were under the effects and then what they said. Because if you do it in reverse order, you may not put on that it was, you know, you may not be able to convince the judge it was in fact an excited utterance.
Statement against interest. So this, it's kind of very self-explanatory, but neighbor says, I heard the defendant say, I can't believe I just killed someone. The hearsay right here is the defendant's statement. That would be the out-of-court statement being offered for the truth, but it's an exception to hearsay because it's against the defendant's interest that they said it at all.
And that can also apply to other possible statements. It doesn't necessarily have to just be like the person, like the defendant in this case. So like the defense could offer an out-of-court statement from, you know, a prosecution witness because it's against the prosecution witness's interest, in which they admit that they maybe lied or that something of that nature. Those are other possibilities. So these examples, a lot of them have to do with the defendant because we have like a fake little criminal case that we're sort of talking about, but that they can apply to other statements as well, I guess is my point.
Yeah. So an example in like a contract case is if you have a witness that was saying, I would never sign that contract. That was a terrible contract. It wasn't enforceable. I would have never signed that. If someone heard them say, I can't wait to sign this contract with so-and-so, that would go against their interest and the statement that they had. Declarants unavailable. I don't know if we're gonna have that one.
I don't think. I think we try to avoid that one as much as possible,
that's like a very tricky one.
to be very honest.
The dying declaration is very similar to the excited utterance in that we think because the person's dying, they really don't have any interest in lying anymore because they're going to be dead very shortly. So you basically have to establish that the person said it right before they died. So it's similar to this excited utterance in that there's a very important moment that happens and very close in time. A statement out of court was made. Okay.
So one of the for the declarant being unavailable, one of them is if they testify they don't remember, then maybe another witness who heard, like in their witness statement, it says, well, I heard them say X, Y, Z, then that may be actually able to come in. Well, they said they don't remember. Do you remember what they said that day? that might get you an exception to the hearsay. Not very often, but that is an example for declarant being unavailable. Like I think we mostly try to avoid that, to be honest.
Yeah. Another one that I don't know we talked about is an exception is that you're not offering it for the truth. You're offering it to show what they did next. So a lot of times with like a police officer, I heard this bang and that's why I ran into the room. You know, I didn't have an, you know, I wouldn't have just run into a room. I can't do that. So, you know, it's not about the truth that like, that's when they were shot. It's to show that's what made these next steps happen.
Yeah. Or the neighbor, I heard the defendant say, I'm going to kill you. Maybe I'm not offering that for the truth of the matter asserted. I'm offering it to say like, and in response to hearing that, what did you do? I called 911 immediately, or I ran over to see if someone needed help or what was going on. You're offering like what the witness did in response to the thing they heard. And so that could get you an exception as well.
Yes. So here it's kind of saying like when this occurs. So oftentimes these objections are going to come right after the lawyer asked the question. So you try and get it in after the lawyer asks the question before the witness answers. Sometimes you have to cut off the witness, but that's the time to do it. A lot of questions are objectionable. So, you know, we did talk a little bit earlier about whether objecting to every question is really useful. Sometimes it is, especially if the question's just, you know, if it's about irrelevant stuff that's going to hurt your client. Sure, just keep objecting. But if it's on little stuff that doesn't really matter, is that a good strategy for you? Okay, these are some fun ones. We talked about asked and answered. Argumentative is one that's like badgering the witness. That's how I usually say it, but that's similar to asked and answered, but it's kind of when you ask a question and make it mean and keep hounding on it. So, you know, kind of making it personal. How can you sit there and lie to the court? Let's see, the leading on, oh, go ahead.
Yeah, say, how can you sit there and lie to the court? The reason we call that argumentative is because you're not really asking a question about any evidence in that point. You're just asking them to justify their own personal character. So sometimes that's when argumentative, it's like you're really just attacking their character personally in a way that's not substantially related to the case. Now, if somebody is lying, you can obviously bring that out. It's like, you said this that time, and you said this now. So were you lying then or are you lying now? Like, that's a fair question to ask.
Fair.
But
say, like,
Stacey, why are you such a liar all the time? You're just a liar. Stop lying.
You're such a liar, aren't you? Like, that's not appropriate. You're a bad person and a liar. And, you know, that's not called for. Leading on direct. So we talked about before that direct examination is the time when the witness shines, right? So you're saying like, you know, what happened next? Why did you sign the contract? Who did you talk to? Those W questions, how did you know? Those are the type of questions you want on direct. Leading is where you kind of say, and then did you sign the contract with Bob? When they've never talked about signing it, they haven't talked about Bob at all. That's when an objection for leading is appropriate, because the attorney should not be supplying facts or kind of leading the witness into what they want them to say. That's why it's really important for direct to practice and to know the witness to know their story, and for you to know exactly what you're going to ask them and the Q&A. How does the Q&A go?
There are also some like basic foundational questions though that like you could object to as leading. For instance, like when you're the plaintiff on this case, is that correct? It's technically leading. It's technically leading. Don't object to that. Don't object to that particular question. You're not going to get anywhere with it. So like Stacey said, I'd make sure we're objecting to really substantive things that matter. So usually what we're concerned about with leading is when, especially if the witness doesn't know the answer to the who, what, when, where, and then the attorney tries to ask it in a yes or no format, definitely like chop that off and object to that as leading.
So compound question is something where there's two things that they're asked to answer. Well, you signed the contract and called Beth, didn't you? That's two questions, and you can't answer both of them with one response. It's an objection you can make, but it's not, listen for them and make them if they're not helpful. But it's basically where there's two facts in one question that you're asking them to validate or deny.
And if you're the witness and you're asked a compound question by the other side and your attorney does not object. So in this case, did you buy the lamp and a sandwich? If you only bought a lamp and not a sandwich, the answer is no. So think about that as a witness. If you don't get the compound objection, what's the answer to the question? Did I buy a lamp and a sandwich? Nope.
And that's beautiful because when you're doing, you never, for example, if that was a cross-examination, I can't follow that up with why. Because then she could just say like, well, let me tell you why. I don't like lamps. I would have never bought a lamp. It's bad, but I love sandwiches. So you don't want, so that's why really listening and answering what was asked and only what was asked can be very useful as a witness.
Yeah, so as a witness, it's helpful to know what the objections are, but also like to know what your answer should be if you don't get the objection that you as a witness think should be made. So that's just what, especially with the compound question, I would think about that as well. And like we were talking earlier, like on a, if you think it's an ambiguous, your answer is really a yes, but just like throw that but in there so that everybody knows that there's more context that's not being given.
Okay, so we talked before about non-responsive answers, where, for example, if you're saying you ask yes or no questions and they're launching into a narrative or a spiel but you really ask yes or no question, that's where you object, non-responsive. An example here is, weren't you the last person who saw the roommate? They didn't have an omelet, completely non-responsive. That would not be great for a witness to do. It wouldn't make sense. Oops, shoot.
Yep.
Okay.
Yeah, I was gonna say the vague and ambiguous there of when did you see it happen? The it is what is vague or ambiguous. Like, when did I see what happen? And as a witness, if I was asked that question, I'd be like, when did I see what happen? Like, I'm just gonna waste your time now on your cross if you ask me that. Like, I don't know. Like,
calls for speculation is a really good one when the witness might not have personal knowledge or it's not everything is in their fact statement. So, what was your roommate's favorite TV show? I'm not my roommate. I think maybe I could guess, but I don't really actually know. This happens a lot of times too when you ask about what another person thought or what motivated another person, how another person felt.
why do you think the defendant killed his roommate? Like, calls for speculation. Like, I have no idea. Like, first of all, I have no idea. Second of all, like, if I gave you an answer, it would definitely be speculative, unless my answer is the defendant told me he killed his roommate because XYZ.
Let's see. Calls for an expert opinion. How did your roommate die? I mean, unless you have personal knowledge because you were there and you saw it, you're not an expert, you're not performing the autopsy, so you don't have that expertise to actually say blunt force trauma. Okay, and then the legal conclusion is something like, for example, if we were to say, did you think this was an enforceable contract? I mean, they can still answer it, but that does technically call for a legal conclusion. Okay. Okay, let's play what's the objection. We only have about 20 more minutes. Do we want to do some of these?
I think we should first open up to questions because we want to make sure we answer as many questions as possible.
You guys will have these slides, so you'll be able to see, the example question, and then we filled in what the objection is. So that might help you to read through those examples.
And you guys can unmute your mics and ask us the question if you don't want to just put it in chat, or we're happy to talk to you also.
What if
I know we're, oh, I'm sorry.
I was just gonna ask, what if there's like a possibility, like there's maybe like I don't know how to explain it, but maybe there's like two possible objections that could be used. Like, how do you determine which one do you use?
That's a wonderful question. You can say both, and you should.
Yep, absolutely make both objections. You don't have to pick one, just make both. If there's, every once in a while, there's like 4 objections, especially to exhibits, there may be 3 or 4 objections that can be made to an exhibit. Make every single one of them.
So for example, you could say like, it's irrelevant, it's more probative or more prejudicial than probative, and it's an out-of-court statement offered for the truth, or you just say, and it's hearsay. That was a good question.
Do you have to know the names of the objections? Like, what if you forget what they are called? It's helpful to sort of try to memorize your main 8 to 10 objections that you would make. So leading, asked, ambiguous, asked and answered, hearsay. If you can't quite come up with the name of it, like you just blank on hearsay, but you can tell me, Your Honor, this is objection. This is an out-of-court statement made for the truth of the matter, made to establish the truth of the matter. I know that that's hearsay. You just told me you don't have to say the word hearsay. I would prefer if you did, because it shows some mastery of the rules of evidence. But as long as you're able to sort of substantively tell me what your objection is, that's what we're looking for.
Yeah, like called for speculation. Maybe you don't remember the word speculation, but you say,
there's no way this witness would know.
Yeah. How would she know is a great, way to explain that. And typically when you object, judges might handle it differently. So sometimes they'll just say objection relevance. And then the judge will say, respond to their side, then ask you to respond. So definitely pay attention to the judge and whether they want you to give your argument, immediately. Sometimes the judge doesn't want to hear the other side respond, and they'll just dismiss they'll overruled, so you sit down.
Yeah, it's every presiding judge is different, and the longer you've done it, the more, some of our judges who've been doing it, I think some of our presiding judges who still preside have been doing it for literally 35 years. And they've done it enough that they have they get a feel for when they need an argument, or when they want to make sure you understand the objection you're making, or when they want to force the other side to respond to it. And just because they asked for a response doesn't necessarily mean they thought it was a bad objection. It's just an opportunity to see if the other side has thought through, again, for hearsay is a great example. If I object to hearsay, maybe the judge is going to ask Stacy for her response. And that's a way for Stacy to say, it's an exception to hearsay, Your Honor, because it's a United excited utterance. So it shows, yes, I have identified hearsay because it is hearsay, but Stacy's identified that as an exception. So, okay, we both have shown that we have mastered sort of what the rule is. There's a question generally about format. As a beginner team, do we go against other beginner teams? No, I'm sorry. It depends on your region and how your particular region does it. I will tell you, in the 2 Dallas regions we run, it's completely random. The first round is very randomized. And then after that, you tend to be matched sort of in a power ranking sort of thing. So winners are competing against winners and losers against losers, and that's just a way to sort of force separation in the standings. But the first round is usually, and especially at state, it's completely random. Literally every school is assigned a letter and then it's thrown into sort of a random generator matchup thing that like some logarithm on the internet, algorithm, I don't know what the difference is. So it's completely random. So you as a beginner team may be up against like you could be up against the state champions from last year. And there's no, like, you just do your best. I think I would just, at the end of the day, you're gonna be fine. You're not getting an F in a class because of how you do at the competition.
Hello.
Yeah, and I mean, the beauty of trial is that, I mean, objections are a time when you're both kind of like talking to each other, but really you're talking to the jury, So you're presenting your case, you're poking holes, using your witnesses and cross-examination. So, yes, maybe one team might be better than the other, but you're still, have ownership of your part of it.
I'm wondering if there's a required amount of people needed for a team to compete.
Yeah, we went over that in the rules. So I just go back and read the competition rules, but generally you have to have 6 people because you need your 3 attorneys and your 3 witnesses. And if you can't get 6 people, you're usually not going to be allowed to compete. We sometimes make exceptions for emergencies that happen like the day of, but usually it's, we'll let you compete at competition, but you can't advance to semifinals if you don't have a full roster. And when I say full roster, I mean 6 people. I don't mean the full 10.
I'm sorry, when did the meeting start then?
It started at 9.
Okay, because what happened was I was first using a school laptop and I think it was blocking me out, so I had to change laptop.
Okay. And that's fine. We recorded the earlier session and that will be sent out to everybody. So if for some reason you don't get that recording, I would check with your coach or advisor or check in with your regional coordinator and they can make sure you get a link to that recording as well. Okay.
Okay, thank you.
One thing that we didn't talk about, unless anyone has more questions, we didn't talk about closing. Real quickly, I just want to go through it. We touched on it earlier, but in closing, it's really important. Closing has to reflect what actually happened in the trial. So while you should prepare your closing and know what you're going to talk about, you cannot talk about evidence that didn't come into the case. So if a document wasn't allowed in the case, you can't like hold that up or say, there was a contract that said, there was a document that said this. That's something to be really careful about. The plaintiff closes and the defendant closes.
And we do allow for, a very brief rebuttal, and the rebuttal you can reserve a minute. And if you end up having like a minute, 20 seconds left over, the plaintiff does, you still only get 1 minute for your rebuttal. It's a very firm time limit. And do a rebuttal. Sometimes I see, every once in a while, I see someone not do a rebuttal and I think you're losing an opportunity to get the very last word, because that's what that means for the plaintiff is you get the very last word when you get that rebuttal.
Like, what's your elevator pitch? What's your 2-sentence thing that you want the jury to take away?
And not just that, what do you want the jury to vote? How do you want them to vote on your verdict sheet? Like, we don't have a real verdict sheet, but in the plaintiff on the clinic case, members of the jury asked that you find that there was an enforceable contract and that the other side breached that contract.
And so for those 3 elements, we want you to check yes, yes, yes. And then the defendant will say, and we showed you, and so we ask you to say no, no, no. Any more questions?
And if for some reason you're shy and you don't want everyone else to see that you're the one that asked the question, you can send it to me in a direct message. That's totally fine. I think that we could just go through these last couple of objection slides just to give them an example to help spot.
Okay. What's the objection? You knew the defendant didn't have a car, didn't you? On direct. And so that's leading because all the facts are in the question, and that's not appropriate on direct. The witness should be talking about their personal knowledge, not the attorney. So this is a good example of a compound question. How did the defendant respond and react when you saw him standing next to the body? Like, after that question is asked, the attorney would stand up and say, objection, compound question. And then typically, you can just say, I'll rephrase, but a better way to then rephrase it would say, what did the defendant do? Did he respond? Something like that. Short and sweet.
Yeah. If that gets objected to, it's like, how did he seem to react? Like, did he have any facial expressions? Did he do anything physically? Did he say anything? Like, you need to be more specific in your question if you get like in a compound objection or even an ambiguous objection.
So this is a good example, I think, of calls for a narrative, or like what maybe is not the best approach for direct examination. So if you just bring your witness up there on direct and say, what's your name? And they say, Jessica. And then you say, okay, tell me everything about this contract. Your witness isn't making a speech. You need to lead them through the points, like, why are you here? I signed a contract. When did you sign a contract? Why did you want to sign a contract? What is the contract about? Things like that. So just walk them through. Always go back to those like W words when you're stuck. Here we go. Here's an argumentative. Wasn't it heartless of you to leave the defendant lying in a pool of blood? Right. Just like we talked about, that's just like you're getting very personal, and it's asking the witness to reflect on like their own, personality or their character. Okay, if we're in a murder case, what's your cat's name? We don't care. So you'd say objection, irrelevant. And the judge would ask the other side to respond, and they probably wouldn't have a very good response. So the objection would be sustained, and the attorney would move on and ask a different question. Seriously, what's your cat's name? Irrelevant, asked and answered. Okay. So whenever, what did another person tell you? What did Anne tell you after she left the defendant's house? That is, if you're asking a witness to repeat something someone else said, or someone else wrote or something like that, that is hearsay. Because it's asking for the statement that is not made via testimony from the witness in person. And it doesn't just have to be, what did Anne tell you? It could be, what did the report say?
I have a question that's been asked. Can the witness just say, I don't know, to every question that's being asked?
They will get 0 points.
Yeah, you're going to get a terrible witness score if you start saying, I don't know, to every single question. Now, if you're asked for something that's outside of your witness statement, I don't know is the correct answer. I don't know. If you don't remember, it's I don't remember. If you start saying that every single time, you're going to get 0 points, and you're probably going to get a lecture from the presiding judge. We have seen that happen many times. Is usually at some point, and if they keep saying I don't know, at some point you could say, Your Honor, I believe this witness is just trying to avoid answering questions. And I would put it in the
non-responsive. Yeah.
What do you do if a witness isn't answering questions properly and just trying to waste time? Non-responsive.
Mhm.
And again, what I have seen is like the presiding judge has some discretion over those timers. And one time I did have a presiding judge stop. I need you to pause the clock. You're going to answer this question and I'm not going to let you waste their time. You're going to answer the question and we're all going to sit here with the time paused until you answer it. That was a very egregious example.
Yes.
Like, we almost never get to that state because usually once the judge says answer the question, people
Yes.
answer the question.
Yes.
That was a particularly hostile issue. What
So
if
always
the lawyer,
listen to the judge.
what if the lawyer only asks questions that the witness cannot know, is a question I just got asked.
Well, I think the witness should then answer truthfully.
Yeah.
I don't know.
And your attorney for your team should also start objecting. Like, they're asking questions that are clearly outside of this person's fact statement. Would ask you,
Call for speculation.
yeah, calling for speculation. And then we're now also asking for unfair extrapolation. We're asking for them to go outside their witness statement where, you're trying to get them to violate the rules and something. And again, only when it really gets bad should that start being your argument. If they ask one question that, mistakenly they thought was in the witness statement and the witness answers it, just, everyone can move on, but it's only when it starts to get really, really egregious.
Mm-hmm. And like we talked about before, like when something's getting difficult, take a breath, rephrase the question, try and clean it up if you need to, say something like, okay, I'm asking you a yes or no question, to demonstrate to the jury that this is just witnesses being unhelpful. And then typically if you go through that a few times, it will be ended by the judge. Okay. About this, what did you hear the roommate say right before he died? They'd say objection, hearsay. The response would then be, this is an exception to hearsay. It's a dying declaration. So that's kind of how it goes. There's an objection. The judge will indicate, but typically then the other side will need to respond to the objection. The judge is usually just going to hear an objection, a response. Sometimes they ask for more, usually they don't. The judge will rule and then you'll act accordingly. So when the judge says overruled, that means the objection does not stand. And when the judge says sustained, that means the objection does stand.
I'm getting a lot of questions in direct messages.
Okay.
Can a witness plead the fifth? The answer is no. A witness is expected to answer any question asked of them, so long as it's within their fact statement and the witness has personal knowledge. I say the witness because it's obviously what you've been told in your statement. What if a question is asked where you're not sure the answer is yes or no? I'm not sure.
Yeah.
That's fine.
Mm-hmm.
Usually the statement should tell you, usually you can, make reasonable inferences from the statement as to whether or not it's a yes or no. But if you genuinely don't think you can, I'm not sure. And sometimes what happens when you say I'm not sure is then you get asked, well, why are you not sure? Try not to do that on cross, because then you're going to let the witness just run wild. As a witness, if you genuinely don't know the answer, it's okay to say, I don't know, I'm not sure. Would you also have to explain the exception when objecting because of hearsay? No, if you object because of hearsay, it's the other side's obligation to say if there's an exception or not. And if you don't think the exception applies and the judge allows you to respond, you can then give sort of a rebuttal response to that. But you're not expected to say, this is hearsay and there are no exceptions or blah, blah, blah. It's okay for you to say it's hearsay. Mm-hmm. Is it okay to add some humor to your answers, or is it better to not? Stacey, I'm gonna let you take that one. I think that's a witness specific question.
A witness specific. Your answer can incorporate humor, but it has to stick to the fact statement. It has to be the actual the witness's actual answer consistent with the fact statement. But if humor is part of the witness's personality, or, you know, the witness is, I've seen it work really effectively a lot of times, you know, like, I don't remember, man, like I was smoking hash, like, sure, like that works and it's consistent with this guy's witness statement.
Now, if you're like a grieving widow and you try to inject humor into your response, maybe not gonna help very much.
You probably won't get the most points that you could. You know, the point of it, when the judges are scoring a witness, they're looking to make sure that you are consistent with your witness statement, that you're you know, you're being that person. You're not there for entertainment. You're there to tell a piece of a story. And you know, how you handle questions on cross, stuff like that. So embrace the witness, like be that person. And you can, if it makes sense, like sometimes it is funny, but, you know, be true to the witness and what they're kind of how they would handle stuff like that.
We love seeing some personality from our witnesses, but don't let the personality overtake the actual substance of what you're testifying to, is what I would caution you on. I've been asked, what if the other side won't let you do your cross because they're just constantly objecting?
That's annoying.
It is annoying. Keep asking your questions is what I would say. Keep asking your questions and trust that the presiding judge is going to put a stop to it. Our presiding judges either have been presiding for many, many years, or if it's their first time presiding, they have scored many, many rounds. You know, we almost never have somebody as a presiding judge who are walking in for their first time and first experience on. I actually can't even think of a single time in the last couple of years where I've been involved on the committee where we've had that happen, because we usually have enough experienced volunteers that just someone who's experienced is going to be the presiding judge regardless. And so, you know, if I'm the presiding judge and they just literally are objecting to every question, I'm going to get annoyed, but also I expect you as the attorney to keep asking your questions and listen to my response, because I might start overruling them because I'm annoyed at the objections. Like that's the reality as a presiding judge, is like, if you start objecting too much, I might just overrule it because I want to give the witness a chance to answer a question also. Can you cry? Can you cry as a witness, Stacy?
Yeah, if the witnesses would cry. I mean, I can't cry on command, but if you can, that's amazing.
Are there any questions about like objections or cross? Because I do have another question I want to address, but I wanted to make sure you guys had a chance to ask us the
one thing I would say about that question about cross, and if someone just keeps objecting, especially on cross, a way to prepare for cross is to make sure your questions are really tight. They're a very clear, short yes or no answer, or yes or no question, because then there's not a lot of objections that actually will be sustained. So like she said, that eventually the judge is going to just take control of their courtroom.
Can you have, what if you have an accent and pronounce things differently? That has never mattered to me as a scoring judge. I've never factored that in. As long as I understand what you're saying, that's important to me. Now, if you put on a fake accent, we may be going down a very different road as to how you get scored as a witness. Because sometimes those, like, again, sometimes that personality starts to overtake the actual substance of the answers. Leah, can you rephrase your question a little bit? I'm not quite sure what you're asking me.
Or maybe like give an example of what you mean.
So I was just asking if like you're speaking to a witness or something, or I guess they're like on the podium and you're asking them questions. Can you make conclusions like, well, I guess since this happened, does that mean this or something like that? Or can you only like, I guess, say things based off of like what the actual proof is or like what's been presented?
So when you're talking to the witness, you should be asking them about things that are in their statement, and so you can, to an extent, make conclusions. So if it says you ran away and you were crying, you could say something like, so you weren't happy about that, were you? That's a conclusion, and it's a question you can ask about a conclusion. So you're not tied to like the exact wording on the witness statement, if that's what you're asking. I think the kind of appropriate time for this is on closing, and that's when you really connect the dots to make more of a conclusion. So saying
Okay,
something-
thank you. I think I worded that wrong, but you kind of
Okay.
clarified what I was asking. Thank you.
Okay, okay, good.
I've been asked about, if you're an attorney and you use your hands a lot or you're very demonstrative, how do we feel about that?
I think it's really important for everyone to remember that everyone has their own style. I've seen some of the quietest, meek people be so incredibly effective. And I've also seen, I am one of those people when I stand up in trial, I can't not use my hands.
Stacey's been using her hands a lot through this. I don't know if y'all have noticed.
I can't not. So, just be yourself. One thing though I would say is you should ask the court if you can move about the courtroom freely. Some point at the beginning, if you're gonna like wander around, you need permission to do that.
Yeah. Usually the answer is going to be no. We want people just to stay at their tables while asking questions. And then you just ask to approach the witness if you need to. And that especially because of COVID restrictions, that's probably going to be more strictly enforced this year, that people stay where they are. And then sort of an addendum to sort of a previous question is if you are asking questions or if you're making objections and the judge keeps overruling you, do you start to lose points if you're the attorney and all of your objections are being overruled? That's going to be it's going to be a really case specific issue. If you're making bad objections that are clearly bad objections, then yeah, I might start docking you. But if you're making a valid objection, and the judge may just overrule you because, again, like I said, we want the witnesses to get a chance to actually testify because they're being scored also. We want to see what they say, how they react to things. So you may get overruled just to give a witness a chance to say what they want to say. I would just keep making your objections, being cognizant of sometimes they're more helpful than others, and keep asking your questions.
Mm-hmm. I think the objections everyone thinks about is like the hard, scary, crazy part. And objections are really important, but don't because they're difficult, right? Like they're abstract, so applying them is difficult to think about now. But, we're judging you on putting on your case. So, when everything gets tied up in objections, that's not helping either team. Objections are appropriate, but putting on your witnesses and poking the holes that you need to poke. That's what the point is.
Okay, there's some more good questions we just are not going to have time to answer. The very last thing I want to address is I know when we first started, there were a lot of questions in chat about dress code, and I've been asked a couple of other questions about dress code. There is not a set specific dress code. Girls do not have to wear skirts or dresses. They can definitely wear pants. And if you can afford to get a suit and you want to wear a suit, you're welcome to do so. We understand some students just cannot afford that. What we expect is that you just look as nice as you can and you're clean and presentable. That's really the expectation. And then you're never going to lose points or anything like that. Witnesses can wear suits if they want to. No one's required, like witnesses aren't required necessarily to wear suits. Attorneys aren't required to wear suits if you can't afford one or can't put one together. Or like me as a female attorney, I oftentimes will just like wear a dress with a blazer over it. Something like that's totally fine and acceptable as well. We just want you to be clean and presentable. We care a whole lot more about what you're saying and what you're putting into evidence. Okay. Well, this is fun. I'm going to let everybody go because we got to go. If you read the rules, read the case, you still have questions that you just don't think are answered, get with your coach, get with your attorney advisor, and they can get with your regional coordinator to try to get you guys answers. Okay.
Have fun.
Yay.
Thanks, guys.